Thank you for visiting the Combs Waterkotte YouTube channel. We are a leading criminal defense law firm in Illinois and Missouri, with over 600 perfect reviews and a long history of client satisfaction, criminal case dismissals, charge reductions, and victories. Our firm has created these audio articles to help protect your freedom, reputation, and rights. If we are hired for your case, we will not give up until you receive fair justice. Grooming Lawyer, Chicago, Illinois. Being charged with grooming in Chicago, Illinois is a serious situation with potentially life-altering consequences. Grooming offenses are aggressively prosecuted and almost always charged as felonies, carrying the risk of substantial prison time, sex offender registration requirements, and long-term damage to your reputation and future. If you've been accused or arrested, it's critical to act quickly and secure experienced legal representation. At Combs Waterkotte, our criminal defense attorneys bring decades of combined experience to cases just like yours. We understand how complex and sensitive grooming allegations can be, and we work closely with you to build a strong defense strategy tailored to your circumstances. If you're facing a grooming charge in Chicago, call 312-500-HELP today to start protecting your rights and your future. Grooming Lawyer in Chicago, Illinois, serving all of Cook County. Grooming charges in Chicago, Illinois can quickly become overwhelming. Between the severe legal penalties and the lasting impact on your personal and professional life, there's a lot at stake. Prosecutors in Cook County take enticement cases like these seriously, often pushing for the harshest penalties allowable under the law. You shouldn't face this situation alone. At Combs Waterkotte, we understand that grooming allegations can arise from misunderstandings, misinterpretations, or even false accusations. That's why we begin every case with a free, confidential consultation to hear your side of the story. From there, our experienced team builds a personalized defense strategy, carefully analyzing the evidence, questioning witness statements, and identifying weaknesses in the prosecution's case. We even have attorneys on staff with Secret Service National Computer Forensic Institute training who understand how prosecutors gather digital evidence and how to fight back against it. Our goal is always to get your charges reduced or dismissed whenever possible. But if your case goes to trial, we're fully prepared to fight for you in court. With decades of combined experience and a deep understanding of Illinois criminal law, we're ready to stand by your side every step of the way. If you're ready to protect your rights, your reputation, and your future, contact Combs Waterkotte online or call 312-500-HELP today. The sooner you have an experienced defense team on your side, the better your chances of achieving a favorable outcome. Grooming definition in Chicago, Illinois. Grooming is a very serious sex offense in Chicago and Cook County, Illinois, due to the fact that the charge involves minors. But what constitutes the offense itself? According to 720 ILCS 5/11-25, grooming takes place when an individual is at least 5 years older than a child or holds a position of trust or authority over a child, and they use in-person or electronic communications to seduce, solicit, lure, or entice a child to commit a sex offense, distribute sexually explicit photos of a child, engage in unlawful sexual conduct with a child, engage in a pattern of conduct that seduces, solicits, lures, or entices a child to engage in unlawful sexual conduct. The statute itself defines some of the terminology used within it. These are the important terms to understand in order to get a sense of what constitutes grooming under Illinois law. Child, any person under the age of 17. Pattern of conduct, 2 or more instances of grooming behavior. Sex offense, in violation of 720 ILCS 5/11, sex offenses. Sexual conduct, masturbation, sexual conduct, or sexual penetration, as defined in 720 ILCS 5/11-0.1. The Illinois Criminal Code doesn't just outline prison terms for grooming offenses, but also sexual registration requirements that can have a lasting impact on an offender's life even if they avoid prison time. What are the penalties for a grooming conviction in Chicago? Grooming is charged as a Class 4 felony in Chicago and Cook County. A Class 4 felony conviction can result in a prison sentence between 1 and 3 years, or a prison sentence between 3 and 6 years, for an extended term prison sentence. Because these are sexual offenses involving minors, Cook County prosecutors may stack additional charges to maximize sentencing exposure. Depending on the specific circumstances of the case, these are some of the additional charges an individual may face in a Chicago grooming case. Online solicitation of a minor, if the conduct began on the Internet. Traveling to meet a minor, if an offender actually attempts to meet up with the child. Predatory criminal sexual assault, if any explicit behavior actually took place. Child pornography, if any digital materials were exchanged. Luring a minor, if the offender attempts to circumvent the child's parent or guardian. A conviction for any of these offenses in combination with grooming can result in several additional years in prison and extended registration as a sex offender in Illinois. Grooming and the Illinois Sex Offender Registry. A grooming conviction in Chicago or Cook County, Illinois requires an individual to register as a sex offender. Specifically, 730 ILCS 150/2 defines grooming as one of the many offenses for which a conviction requires sex offender registration. As to the length of registration, 730 ILCS 150/7 indicates that individuals convicted of grooming must remain registered as sex offenders in Illinois for at least 10 years. Being a registered sex offender can bring a whole host of collateral consequences, like difficulty finding employment. Employers run background checks in Chicago and Cook County, and may exclude individuals convicted of child sex crimes. Limited housing options. Chicago residents on the sex offender registry may not be allowed to live within certain distances of schools or parks. Child custody and visitation issues. If you have children, a child sex offense conviction may lead to custody issues or even orders of protection. Loss of firearm rights. A felony conviction in Illinois may result in the loss of lawful firearm ownership. Criminal defense strategies against Chicago, Illinois grooming charges. If you've been arrested for or charged with grooming in Chicago or Cook County, you need legal assistance right away. The Chicago criminal defense lawyers at Combs Waterkotte have experience helping Chicago residents in child sex cases, and we've found the following criminal defense strategies to be very effective at securing acquittals, charge reductions, and dismissals. Challenging lack of intent to commit a sex offense. A strong defense in Chicago, Illinois grooming cases is demonstrating a lack of intent to commit a sexual offense. Prosecutors must prove that the defendant's communication was aimed at facilitating illegal sexual conduct, not just inappropriate or ambiguous conversation. Defense attorneys can argue that messages were misinterpreted, taken out of context, or never progressed toward actual criminal conduct. Without clear intent, the state cannot meet its burden, which can lead to reduced charges or a full dismissal. Entrapment in online sting operations. Entrapment is one of the most relevant defenses in Chicago grooming cases, particularly those involving undercover officers. This defense argues that law enforcement induced or persuaded the defendant to commit an offense they otherwise would not have committed. If officers initiated the sexual nature of the conversation or escalated it beyond the defendant's original conduct, the case may not stand. Successfully raising entrapment can result in an acquittal if predisposition is not proven. Fourth Amendment violations: illegal search and seizure. Digital evidence is central to grooming prosecutions, but it must be obtained lawfully. If Chicago or Cook County police accessed a defendant's phone, computer, or online accounts without a valid warrant or legal justification, that evidence may be suppressed. A Fourth Amendment challenge can significantly weaken the prosecution's case, especially when chat logs or messages are the primary evidence. If key evidence is excluded, the case may not be able to proceed. Fifth Amendment violations and improper interrogation. Statements made during Chicago police questioning can be powerful evidence, but only if they're obtained legally. If a defendant was subjected to a police interrogation without being properly advised of their rights, those statements may be inadmissible due to Fifth Amendment violations. Additionally, coercive or deceptive interrogation tactics can be challenged. Suppressing a confession or damaging statement can dramatically alter the case, particularly where the prosecution relies heavily on admissions to establish intent. Miranda rights violations. Closely related to Fifth Amendment protections, Miranda violations occur when law enforcement fails to inform a suspect of their right to remain silent and to have an attorney present. In Chicago grooming cases, defendants may make incriminating statements during or after arrest without fully understanding their rights. If Miranda warnings were not properly given, those statements can be excluded, potentially removing critical evidence the prosecution needs to prove its case. Challenging identity and digital attribution. In online grooming cases, the prosecution must prove that the defendant was the actual person communicating with the alleged minor. Defense attorneys can challenge whether someone else had access to the device or account, or whether the evidence reliably ties the defendant to the messages. Issues like shared devices, hacked accounts, or incomplete forensic analysis can create reasonable doubt about identity, which is essential for a conviction. Insufficient evidence and reasonable doubt. Ultimately, the prosecution must prove every element of grooming beyond a reasonable doubt. Defense attorneys can focus on gaps in the evidence, inconsistencies in communication records, or the absence of clear steps toward committing a sex offense. If the case relies heavily on ambiguous messages or lacks corroborating evidence, it may not meet the required legal standard. Highlighting these weaknesses can be an effective path to acquittal or dismissal. Negotiating charge reductions. In some Chicago grooming cases, defense attorneys can negotiate with prosecutors to reduce the charges to a lesser offense that carries fewer long-term consequences. This may involve challenging weaknesses in the evidence, raising legal defenses, or highlighting mitigating factors such as lack of criminal history. A reduction could mean avoiding mandatory sex offender registration or lowering felony sentencing exposure. Skilled negotiation can significantly impact sentencing, helping defendants minimize penalties and protect their future. What to do if you're arrested for grooming in Chicago, Illinois? If you're arrested for grooming in Chicago or Cook County, what you say or don't say to police after your arrest will have a direct impact on the outcome of your case. The expert criminal defense lawyers at Combs Waterkotte highly recommend the following steps for anyone facing a grooming charge in Chicago. Exercise your right to remain silent at all times. If you are arrested for grooming in Chicago, you have the right to remain silent. You should use it at all times. Law enforcement may try to get you to explain messages or intentions, but anything you say can be used against you. Even seemingly harmless statements can be misinterpreted. Decline to answer questions and clearly state that you wish to speak with an attorney before any interrogation continues. Ask for an attorney immediately. One of the most important steps after an arrest in Chicago or Cook County is requesting a criminal defense attorney right away. Never wait or assume you can handle the situation yourself. An attorney can guide you through police questioning, protect your rights, and begin building your defense immediately. Early legal intervention can prevent mistakes and help preserve critical evidence that may be essential to challenging the charges. Do not consent to searches. Chicago police may ask for permission to search your phone, computer, or home. You are not required to consent to searches if they do not have a search warrant or probable cause, and it is usually in your best interest to refuse. Digital devices often contain the primary evidence in grooming cases, and consenting to a search can make it easier for law enforcement to build a case against you. Clearly and respectfully state that you do not consent and wait for your attorney. Avoid discussing the case with anyone. After a grooming arrest in Chicago, avoid talking about your case with friends, family, or anyone other than your lawyer. Conversations, especially texts, emails, or social media messages, can be used as evidence. Even private discussions may later be disclosed in court. Keeping details of your case confidential helps protect your defense and prevents misunderstandings that could harm your legal position. Comply with release conditions. If you are released on bond, carefully follow all conditions set by Cook County Court. These may include restrictions on internet use, contact with minors, or travel limitations. Violating these conditions can result in rearrest or additional charges, making your situation more difficult. Strict compliance demonstrates responsibility and can be viewed favorably by the court as your case progresses. Stay off social media. Avoid posting anything on social media while your case is pending. Cook County prosecutors and investigators monitor online activity for statements, photos, or interactions that could be used as evidence. Even unrelated posts can be taken out of context and used against you. Staying offline helps minimize risk and ensures you do not unintentionally harm your defense or complicate your legal situation. Combs Waterkotte is a leading criminal defense law firm serving the entire states of Illinois and Missouri. We have offices in St. Louis, Chicago, Kansas City, Clayton, Branson, and Belleville. We look forward to helping you with your criminal defense attorney needs.